My dear friends and fellow citizens, I would like to share my views on the ongoing controversy about harsh criticism of the Apex Court judgment in governor's role by BJP leaders and more particularly the Vice President of India, JagadeepDhankhar's selective attack on higher judiciary, followed by BJP MP Nishikant Dubey harsh comments against the judiciary. As you know well, that the office of the Vice President of India is a constitutional post. The person who is holding the office of the Vice President is expected to maintain non-partisan, neutral and equidistant attitude towards politics once he assumes office. However, the present incumbent of Vice President's office, JagadeepDhankhar, is more BJP spokesperson than the Vice President. His selective reactions to the Supreme Court judgments and in the blatant manner in which he conducts the proceedings of the Rajya Sabha, suppressing the voice of the opposition, is a clear transgression of his office character. Before becoming the Vice President, Dhankar was notoriously famous as a West Bengal governor with his constant confrontation with the elected government headed by Mamata Banerjee most of the time, much against the advisory role of the governor and democratic spirit, which he is now hanging upon. 2 days ago, he made very critical comments and criticism of the latest Supreme Court judgments on the governor's role and the President of India and its observations in Waqf Amendment Act 2025 case on its constitutional validity and the Supreme Court's inclination to halt its enforcement, due to which the Modi government is frustrated, and the said frustration was reflected in his caustic comments. He took a swipe at the judiciary on its judgment on the interpretation of the powers of the governor and President of India in relation to the passing of bills. He stated that judges in the country have no accountability and law of the land does not apply to them, and they will legislate, will perform the executive functions and will act as a super parliament. He called it as an incursion by the one institution into the domain of other institution, and it is not good. He criticized the Supreme Court for its over-reliance on Article 142 of the Constitution, which gives special powers to the Apex Court, and described it as a nuclear missile against the democratic forces available to the judiciary 24/7, and said that there cannot be situation where President of India is given directions to the judiciary. While making wild allegation that Article 142 is a nuclear missile against democratic forces, he conveniently forgot the truth that the same Supreme Court invoked the same Article 142 to give relief in Ramajanma Bhoomi case beyond the strict adjudication of the issues of title, which was in favor of his party. Then it was not a nuclear missile. A very fine judgment. But the judgment in governor's case and the Supreme Court's inclination to grant interim stay of the provisions of the Waqf Amendment Act is not to the liking of his party, and as such it became a nuclear missile against democratic forces. He also criticized the way in which the Justice Verma of Delhi High Court corruption episode case being dealt by the Supreme Court and alleged that without allowing criminal investigation, by sarcastically commenting that it is more over a month, even if it is can of worms, and even if there are skeletons in the cupboard, time to blow up the can, time for the cupboard to collapse. Let worms and skeletons in public domain so that the cleansing takes place. He further alleged that an FIR can be registered against anybody, including the constitutional authorities, but in cases of judges, permission is required to it. In this context, it is pertinent to note that Mr. Dhankar, who never allowed any reasonable opportunity to the opposition in the debates and even resorted to mass expulsion of MPs from Rajya Sabha to pass government bills without proper debate and democratic discussion, took initiative and invited all the opposition parties to bring back NJSC Act, National Judicial Appointments Commission Act, which was struck down by the Supreme Court in 2015 as unconstitutional, only to take advantage of the situation of Justice Verma's case and to bring judiciary under the control of executive government, obviously now run by his party. But the same man shows his true colors of selective acts in not allowing the discussion on the blatant communal and divisive remarks targeting minorities, and by participating in RSS affiliated outfit meeting of a sitting judge of Allahabad High Court, Yadav, in spite of the motion signed and submitted by 55 Rajya Sabha MPs. Thus, JagadeepDhankhar displayed his double-tongued policy to please the bigwigs of his party, perhaps eyeing at the office of the president after the expiry of his term as vice president. He went to the extent of saying to the Supreme Court of stating that we cannot have a situation where you direct the President of India, and on what basis? The only right we have under the Constitution is to interpret the Constitution under Article 145, Clause 3. While making this selective, unprecedented criticism, forgetting the fact that he is holding a constitutional office, knowing fully well that the judges cannot react publicly, he grossly overlooked the intent of the Indian Constitution, which is the supreme law of the land, and every institution and every office shall function in accordance with and in obedience to the Constitution. At this juncture, it is appropriate to refer to the debates in the Constituent Assembly about the supremacy of the Parliament and its unbridled power to amend the Constitution. And then it was argued that it was difficult to get 2/3 majority of the members present in both houses and a simple majority of the total members. It was also argued that it was very difficult to get ratification by half of the state legislatures for getting an amendment passed. It was constitutional amendment passed. It was therefore argued that such a rigid provision to amend the Constitution would not permit the Constitution to adapt to the changing times. But we must recall the father of Indian Constitution, what Dr. B.R. Ambedkar, what he said, and he strongly defended this tough provision while acknowledging the need to ensure that the Constitution be remained flexible to the changing times and needs. Warned that cannot be used by the political party to further their ideology and agendas. He stated that if the power is given to Parliament to amend the Constitution very liberally, then the danger of a particular party finding it difficult to implement its agenda and amending the Constitution to implement its ideology cannot be ruled out. And this could not be permitted, though a provision has to be made to adopt the Constitution to the changing needs. It cannot be permitted to be amended at the sweet will of the majority. Such was the foresightedness of Baba Saheb Ambedkar, and now we witness the situation as anticipated by him, and it is now coming to the fore as reflected in the comments made by JagadeepDhankhar and Nishikant Dubey. The Constitution of India ensured checks and balances among legislature, executive and judiciary, the three pillars on which the effective functioning of the government rests, by striking balance in their powers and functions, making the supremacy of the Constitution, maintaining the supremacy of the Constitution. Thus, all the institutions work within the boundaries and peripherals set by the Constitution. The judiciary, as the custodian of the Constitution, it is an independent wing free from interference of the executive or the Parliament, with the power to review the administrative and legislative action by scrutinizing the constitutional amendments in the light of the spirit of the constitutional provisions and declare them as unconstitutional, protecting the sanctity of the Constitution and the fundamental rights of the citizens guaranteed under the Constitution. Thus, the judicial review is a strong tool to keep check on the executive actions and public institutions, rendering their accountability, and such power was provided in Articles 13, 32, 131, 136, 142, 143, 226 and 246 of the Constitution. The supremacy of the Constitution was reinforced and upheld by the Supreme Court in a series of judgments in cases like Keshavananda Bharati versus State of Kerala 1973, Indira Nehru Gandhi versus Rajanarayan 1975, holding that the basic structure including the preamble of the Constitution was reaffirming by those judgments. The doctrine of separation of powers and supremacy of the Constitution is the basic structure of the Constitution. One should not forget this fact. Parliament or executive means the government, does not have any absolute power to amend it or override it. The very preamble of the Constitution declares that the ultimate sovereigns are the people of India. People of India, ultimate sovereigns are people of India, and the Constitution was enacted by them and presented to themselves. So, delegating their will to the legislature, executive and judiciary, assigning their respective powers and duties to discharge their constitutional obligations and duties. So, JagadeepDhankhar or the Nishikant Dube's impatient outburst against higher judiciary is totally misconceived, unwarranted, and not befitting the constitutional office which they are holding. They must maintain the dignity and neutrality, impartiality of equidistant, and more particularly JagadeepDhankhar, being a vice president and Rajya Sabha chairman, ex officio Rajya Sabha chairman, he must maintain the dignity, neutrality, impartiality, and equidistant from his political interests, and should not try to influence or prevail upon the judiciary by his selective outrage. And by doing so, he is behaving more as a spokesperson of his party and becoming disgrace to the office of the vice president. With due respect to him, I hope that a better sense may prevail on him to control his affiliation and public support to the public political interest, at least till the end of his term. I hope that the democratic forces will take care of, will be vigilant to take care of the unnecessary, unwarranted attacks on the Constitution and the Supreme Court, the constitutional courts, whenever they give judgments not in their favor. So it is for the people. It is for the people of India to safeguard the Constitution and its institution from the onslaught of this kind of communal forces. So I take this opportunity once again to appeal to all the fellow Indian citizens to take pledge to protect the Constitution and the institutions which are conducting themselves in accordance with the Constitution by not bowing to the dictates of the government of the day. So this is my appeal to all the people, my fellow citizens. Thank you. Jai Bhim, Jai Bharat.